Hi, it's Mike DelSignore. In this video, I want to talk about a type of case that I've defended people on many times. It's open and gross lewdness or indecent exposure. These charges often can come about for somebody that has some mental health issues or somebody who's going through a tough time. And generally speaking, these are charges you want to try to resolve. Typically, the evidence will be fairly strong in the case. It's usually going to be an eyewitness. If an open and gross charge, I've had cases where people have been in their car exposing themselves, or in parks or public places. And what I typically recommend is whoever is charged with this offense to get help, get a letter, get some kind of support, and try to figure out and get to the root of what's going on here, to try to convince the DA to amend or reduce the charge, or to treat the case as in a diversionary way. Pretrial probation is something where I'll recommend, where the person agrees to comply with certain conditions. In exchange, the case gets dismissed. Open and gross lewdness is a felony offense, whereas indecent exposure is a misdemeanor. So sometimes the best we can hope for is a reduction from a felony to a misdemeanor. Indecent exposure can be a charge to somebody going to the bathroom in public, or some variations of it. So the difference between an open and gross, which is a felony, and indecent exposure is that open and gross lewdness has the element of alarm or shock. So the idea is that the exposure is done with the intent to alarm or shock one or more people, whereas indecent exposure is somebody's exposed themselves in public, but there was no intent to alarm or shock. The classic example, somebody sort of going to the bathroom on the side of the road. You don't see a lot of police officers charging that, frankly. It happens. That is a type of charge I think most DAs would dismiss and be more lenient on. So, what they look for in these cases is they just want to make sure, one, is there a threat to a child, to the public? So where does it occur? What's the circumstance behind it? And does the person have a record? So a person with no record, a lot of times we can show, get treatment, get help, sort of come up with a plan where the DA can understand that this is an isolated incident, show that there's family support, there's counseling involved, that there might be some kind of mental health issue, alcohol, or something that would explain the conduct in the case. So when these cases happen, there's an arraignment date. That's the first court date. After that, there'll be several pretrial dates where you can attempt to resolve these cases. One of the types of resolutions, what's called the continuance without a finding, that's an admission to the charge. That would mean you admit to what the government said, but it's technically not a conviction. An open and gross lewdness, if there's two convictions, two guilties, that the person would have to register as a sex offender. Indecent exposure doesn't have any sex offender registration implications. And a continuance without a finding on an open and gross lewdness would preclude that. So you need two guilties, two convictions. So these cases, generally at the arraignment, there probably won't be any issue of bail unless the person has a record, but there might be some conditions of release. But it's important for us, as your attorney, for me to kind of get at the cause of this, try to figure out who's supporting you in your life, to try to come up with a plan so I can make a recommendation to try to get the charge dismissed. Now, you're presumed innocent. There very well can be defenses to these cases. In today's video, I'm speaking more practically. In most of these cases, the evidence is going to be strong, but of course, they still have to identify you. They have to get the right person. The witness or the victim would have to show up to court. So you could take the case to trial and require them to prove it beyond a reasonable doubt. But for many people, you want to know what your options are before trial. Trials can be uncertain. The penalties can be more serious after trial. You get a convictions versus continuance without a finding, and there's a chance maybe you can resolve the case without an admission. So we always explore that in every criminal case to try to see what can happen without a trial. What's the best way to resolve the case? So if you have questions about this charge or any type of criminal charge in Massachusetts, feel free to call me. My name is Michael DelSignore. Handle these cases frequently in court. You can call, text anytime at 781-686-5924. I'm here to help you. I'm passionate about criminal defense, and what I'll do is try to find a way to help you get your life back and to resolve the case in the most favorable way possible. So feel free to call me anytime.